So looking at my calendar, Mr. Thompson, it's interesting that you'd be right in the middle of jury selection had this trial gone forward. What are you doing now this summer? The fact that your calendar kind of opened up.
Well, we still have plenty to do. As you might recall, Judge Hippler is having us address all the different filings with the court that were sealed. There are 240 some odd filings over the past 2.5 years. Most of them were sealed to protect the jury pool. And now that the case is resolved, we're expecting that most of those filings can be unsealed. But what the court is having us do, he's giving us chunks of like 40 documents at a time to review and let him know whether there's anything that needs to be redacted or protected before they get unsealed and released. So that's consuming plenty of time right now.
How long do you expect that process to last?
I would guess it probably at least a month or so. 40 at a time for 240, probably a couple months.
Wow.
He's given us 14 days on each batch. And he's going backwards. He's starting with the most current sealed documents because those are the ones he's most familiar with. If you recall, the case was originally with Judge John Judge up here in Latah County. So everything that was sealed prior to the case being transferred last fall to Ada County, Judge Hippler is going to have to re-educate himself on what those filings were about so he can make a good decision on whether there's something that needs to be protected.
There also is the police records, which seem to be coming out bit by bit, different media outlets requesting those. Any idea of how much more evidence is out there that the public hasn't yet seen?
Well, when we're talking about how much evidence is out there, as far as evidence that's actually relevant to the charges that would have been brought out at trial, that's probably much smaller than the totality of all the information that was gathered by the investigators, because we have literally gigabytes of data, security videos from around town, from the University of Idaho, for example, that in the end didn't have anything of relevance, but they were gathered early on in the investigation because the investigators were looking for any possible leads to pursue. As far as the police reports, photographs, crime scene photographs, and other evidence like that, the Moscow Police Department and the Idaho State Police are the ones that are the custodians of those records. And so that's why you're seeing the city of Moscow trying to be proactive with getting reports available to the public. And I think they're working on other materials, videos, and photographs to try to get those ready for the public. And I understand the state police are doing something similar. So as quickly as they can act, it'll be unfolding for the public with, of course, review and appropriate redactions.
Having reviewed all of that, what in your eyes is the most disturbing thing that you've seen with this case?
Well, certainly the crime scene itself was very disturbing. The photographs are very graphic. My personal preference is I don't think that many of them should be just generally given out to the public. I think that certainly the public has the right to know, but the families also have some privacy interests. And I think that that needs to be balanced. In the end, it's not our office's call. It's going to be the attorneys for the city of Moscow and for the state police as far as how much they believe is appropriate to redact. And again, balance. We want the public to know as much as possible, but we don't want this to become unnecessarily or avoidably painful for the families to have to see what occurred to their loved ones. It's very, very sad. It's going to be very difficult, I'm afraid.
I know Judge Boyce in the Daybell case permanently sealed the autopsy photos and some of the crime scene photos. I guess that could be an option here if Judge Hippler decides to keep some of those items sealed forever.
Well, I'm not sure that Judge Hippler has the jurisdiction on that now because the criminal case
Right.
is pretty much precluded or concluded. We're operating under Idaho's public records laws, and there is a specific exception or exemption for unwarranted invasions of personal privacy. There's a definition for that, but it requires a balancing of the public interest and the privacy interests. And that's what I know the city of Moscow and the attorneys for the state police are working through. Again, my perspective as the prosecutor is to want to protect the families as much as possible. And I don't see a necessity for saturating the public social media with gruesome photographs of these poor victims, but it's not my call to make.
Right. I want to talk about the plea agreement that, of course, there has been some heat and some criticism against you in your office. Do you think that that whole process could have been handled differently or better as far as coordinating with the families?
I think the plea process happened as well as it could given the circumstances. And just to give you background, the state, we were never looking for a plea in this case. The defense had maintained all along that their client was factually innocent. So for months now, we've just been preparing for trial. We were in the process of doing that. We came up into, I'm looking at the calendar, June 18th, we were in Boise for hearings on the defense's motion to continue the trial and also a motion they filed asking for permission to offer alternative perpetrator evidence. It was pretty clear at the conclusion of that hearing that Judge Hippler was not going to grant either of those motions. Again, Ashley Jennings, my senior deputy, and I just came back to Moscow and we're continuing to prepare for trial when the defense reached out to us that following week and asked if we were able to make an offer or were interested in making an offer. And we responded initially by saying, well, what is it that your client wants to do or is willing to do? And then the next thing we did is we scheduled meetings with all the families. And that Thursday and Friday, that'd be the 26th, 27th, we met with representatives of all four of the homicide victims' families to update them on the case. And we asked them, we said, we've been approached by the defense about a possible plea and we'd like to have your thoughts. And the result of those meetings is, I think, as to be expected. There were some family members who felt strongly that they wanted the death penalty pursued no matter what. And then there were a number of other families and family members who said equally strongly that they wanted to have closure. They did not want the trauma of the trial. They wanted to be able to heal and move on. So we took all that information, all those responses with our attorney team, and over the weekend discussed it. And we responded to the defense by saying, essentially, if the defendant wants to avoid trial, there's only one possibility. He pleads guilty straight up to everything, understanding that he's going to be facing fixed life sentences, and we will require him to waive appeal. And that's the only resolution short of trial that's out there. And by Monday morning, we were advised by the defense, they advised us in the court, the defendant was prepared to plead guilty on those terms. And so the judge set it as quickly as he could for a change of plea, because the court staff were already in the process of bringing in, I believe, 10,000 prospective jurors to start jury selection. And the judge, rightfully so, knew that he needed to move quickly. We needed to move quickly to get the plea on the record if that's in fact what was going to happen. So I think in hindsight, the process was as good as it could get. I know that some folks would have liked more time to think about it and to talk about it. And I respect the opinions of the family members who don't agree with this resolution. I understand that. Just the same as we respect the opinions of the family members who support this resolution. In the end, it was our decision, ultimately my decision as the elected prosecutor, and with the input and concurrence of our attorney team, we decided to make the offer for the resolution, and we believe that's the appropriate resolution.
Is there a way that you can meet with those families and go through your case with them now? Like, this is who we would have called, this is the evidence they would have said, just to maybe get some of those answers for them?
Yes, and we've offered that. And the Monday before the sentencing, one of the families met via Teams with the two lead investigators, and Ashley Jennings, my senior deputy, and Josh Hurwitz, who's our special deputy prosecutor. And they spent a lengthy time that afternoon. I wasn't able to attend, answering questions for the family, letting the investigators share information that we couldn't make public before to try to answer some of those questions. And we're offering the same opportunity to any of the other families if they would like to talk, and we're going to leave it up to them as to if and when they want to have that conversation.
Could you have required him to allocute to talk about talk more? I mean, he didn't say anything, meaning Bryan Kohberger.
We thought about what sort of allocution would be required for the plea. Idaho law doesn't require a detailed factual allocution, and in fact, the court doesn't have the authority to compel that. Um, our feeling on this, and Judge Hippler talked about this too at the time of sentencing, is in this particular case, there would be no way to corroborate or to validate anything the defendant might say. In fact, early on in this investigation, we had members of the FBI's Behavioral Analysis Unit, BAU, which are their profilers. They were here helping us with the investigation, and they even told us back then, back in November of 2022, early December of 2022, that in all likelihood, whoever was responsible for these murders, the reason that the murderer did what he did, would never be known, or if the person tried to say something, it wouldn't make sense to regular people, ordinary people, and likely be even more victimizing. So we elected to not try to pursue anything further than making sure we had a sustainable, factual guilty plea where, as he did under oath, he acknowledged that the charges against him were factually true. It wasn't one of these cases where there was an Alford plea, which is where a person pleads guilty saying that they acknowledge that the evidence is enough to convict him. Here, he acknowledged that he was guilty. And we felt that was the best thing to do in this particular case.
Bill, could you, well, let me rephrase that. Why do you think he took the plea? Why do you think he changed his mind and in the matter of days it went from we're going to trial for 3 months to I'm guilty?
Yeah, Nate, I don't know the answer to that. I think the reasons behind um, why the defendant did what he did as far as pleading guilty are really known only to him and his attorneys. And I don't know if they would be able to talk to you about that, but that's where I would ask.
Yeah. I want to ask you about Dylan Mortensen and her victim impact statement. Tell me, I learned that she did not want to look at Bryan at Kohberger.
Correct. She did not want to look at the defendant, and she did not want him to look at her. And she asked first if she could give her statement seated at the table, the council table, as opposed to standing at the podium. And Judge Hippler very graciously said, certainly yes. And then she asked me, because I was sitting on her left, if I would block the view between her and the defendant while she was giving her statement. So that's what occurred in court, and people might have wondered why I was kind of sitting at a little weird angle, looking just straight at Dylan, and that was because she wanted to have some physical protection and asked us to do that for her.
I can't imagine the preparation that went into helping her prepare for that statement. Well, originally to help her prepare to testify. What type of things did you all do to help not only her, but the other victims prepare to go into that courtroom and give their statement?
Well, we did a number of things, and fortunately, both of the surviving roommates have really strong family support and personal support through family and friends and other resources. And so we largely let them have their peace and have their time. We consciously made the decision not to start specific trial preparation discussions with them too early. In fact, we were planning on doing that about this time while we were still doing jury selection, so they weren't, so that the trauma wasn't raised and they had sustained living with that any longer than necessary in anticipation of going to trial. Of course, we had a grand jury. And although I can't talk about what actually happened to the grand jury, you can imagine that a grand jury would be an opportunity for potential witnesses to be meeting with us meeting with them. But the families really did this on their own, and we said we're here for whatever you want, whatever we can do. Just let us know. We want you to have your space. We want you to be healed and as strong as possible.
Did
It
you
was
know?
it's tough for him. It's been tough for him.
Right. And did you know what each of them was going to say?
No, no. We were well, actually, no, I take that back. We were aware of Bethany's statement because Bethany's wrote out her statement and had one of her college friends, Emily, read that. So yes, we did have that in advance, but we did not know what Dylan was going to say, nor did we know what most of the other victims or family members were going to say. It was pretty fresh to us hearing it in court as it was for everybody else in the courtroom.
And what was your reaction hearing some of those? I mean, you got emotional at points when you were speaking, but there were some of those statements were very emotional and very raw.
They were very emotional. They were very honest. The strength that not only Dylan and Bethany showed, but the family members who were suffering this, horrible, unimaginable loss. Um, the strength that they showed. You had the whole variety of reactions, just as we expect. People are going to grieve differently. Some grieve with anger, some grieve with self-reflection. And we saw all of that in the courtroom on July 2nd. It was, or excuse me, on July 23rd. I believe it was on July 2nd. So on July 23rd, we saw all that range of emotions. It was powerful. And if you were watching, you saw that even the court teared up. And I think there were probably times during that sentencing hearing where there wasn't a dry eye in the entire courtroom
Yeah.
from not only family members, but law enforcement who were there to watch. The attorney general was there. Um, the court security staff. This impacted everybody.
The whole world. Can I ask you a procedural question, Bill? I've
Sure.
covered other sentencings where the victims are not allowed to address the defendant. They have to address the court. And in fact, in the Daybell sentencings, the court, I believe, had to pre-approve some of they couldn't say certain things. Was that different here because this was a plea agreement and he had already pleaded guilty, or just a different judge deciding to be a little bit more flexible? Any idea?
Nate, it's a little bit of both. In a death penalty case, during the punishment phase of the trial, victims are allowed to make impact statements, but Idaho law specifically prevents them from giving opinions about the defendant or for advocating for a specific sentence. The impact statements in the penalty phase of a death penalty case are restricted just to the impact of the losses on that particular family member or on the family. That doesn't apply in other types of sentencings in criminal court. And so it really is left up to the judge's discretion. And I've been in front of judges who have made it clear up front that he or she wants the victim impact statements directed at the court, not at the defendant. But in this case, Judge Hippler allowed some of the family members who wanted to address the defendant directly. I think that in this case, that was appropriate. I think that was important for those family members to have that opportunity to make it known clearly to the defendant what they think of him and what he had done, what the impact had on them from his killing their loved ones.
What do you think is the biggest misconception about this case?
Yeah, I don't know that I have an answer to that. I'll be candid, Nate. I have not consciously followed a lot of the media, particularly social media stuff. I mean, I read the newspaper, I listen to the local radio station, and that's about it. And so I'm not, I consciously didn't want to get myself distracted with whatever was going on out there in the world. I had enough people come in and talk to me about, well, there's this rumor and there's that rumor. And, I knew in my own mind that so much of that was just made up. It was speculation. It was people grandstanding for some folks. Um, so, yeah, I don't know from the public's perspective, what would have been the most significant portion or troubling or compelling portion of this case. I guess I'd have to say in the end, it's the loss of those 4 lives for no reason and in such a brutal fashion. I mean, at the beginning and at the end, that's what this is about: is Maddie, Kaylee, Ethan, and Santa, and certainly also Dylan and Bethany, who fortunately were not killed. Like I said in court, I mean, they had angels watching over them that early morning. That's the only explanation I have for why we didn't have even more tragedy in the form of more murders.
Do you believe confidently 100% that Kohberger acted alone?
We don't have any evidence to indicate that there was another person involved, and the investigators looked. Uh, that said, I guess there's always a possibility that there's something out there that is unknown to the investigators and to us, but there has been nothing that the investigators found to suggest that was actually the case, that somebody in addition to Mr. Kohberger was involved. The recreations that the investigators did using the amount of time that we know he was in the house based on the audio from the next door neighbor's surveillance camera, and our consultation with our crime scene experts, is there was more than enough time for him to do what he did by himself. Dylan didn't indicate that there was any more than one person there. There's just nothing to suggest that there was truly anybody other than the defendant.
And do you believe that it was just the one knife?
I believe that the K-bar knife was the weapon used to kill. I also think it is possible that he had another weapon of some type. I don't know if it was a blunt force weapon or something. I think that it is likely that he had more than one weapon with him, but we don't know what that actually would have been.
And do you believe that had he not left the sheath behind, would you have been able to capture him?
We've had this conversation with the investigators on more than a handful of occasions. The question of whether this case could have been solved without the sheath. And I'm relying on the investigators when they say, yes, we think eventually we would have found him, but it may have taken a very long time. Certainly from a prosecutor's point of view, the DNA on the sheath was compelling evidence to support this case. In fact, we did not file charges until we had the preliminary parental DNA match. If you'll remember, before he was arrested, before he was charged, the FBI did what's called a trash pull at his parents' residence in Pennsylvania, where they seized the garbage that had been set out from the house for collection and shipped the bags of garbage to the Idaho State Forensic Lab. And the forensic people found a cotton swab that looked like somebody used to clean their ears, and they recovered DNA from that swab that came back conclusive as coming from the father of the person whose DNA was on the sheath. And at that point, we knew we had the right person. And then after he was arrested, we obtained a DNA sample directly from him after he was transported back here to Moscow. And then the lab conclusively matched that to the DNA on the sheath. Powerful evidence. Hard to explain that one away.
Right. And really, yeah, I mean, that's like a movie script in a way. I don't want to make light of it, but connecting all those dots and finding him there. And there are people who are concerned that Bryan Kohberger might do some exclusive interview and make $1 million or write a book or produce a movie. What can you say about that? Are inmates allowed here in Idaho to do that?
Now, I don't know that there's a prohibition on an inmate talking to an author or the media or whatever the case may be, but Idaho does have a specific statute that says if a murderer receives any remuneration, anything of value for talking or for giving their story or sharing their story, that's impounded by the state treasurer and held to be available to the families of the victims for their losses. So there's a specific statute in Idaho that would intercept anything like that and save it for the victims' families.
Could his family though? I mean, like could someone make an agreement maybe with his parents where Kohberger then speaks, but the money's funneled another way?
I suppose that's possible, and I don't know what the best way to deal with that would be. The criminal system doesn't have direct means of addressing that. I think certainly if any of the families want to pursue him civilly, there's much more authority for a civil court to locate assets that might be hidden in the hands of third parties and that sort of thing. So that's an option that the law makes available to any of the families who are interested, but it's beyond the scope of what we can do with a criminal case.
Right. Have you spoken with Kohberger's family?
I have met his mother and father briefly, but no substantive conversation with them.
And would you want to speak to Bryan Kohberger himself?
I don't think so. If he wants to talk to somebody, we have some good investigators that he's welcome to talk to. I don't feel like I have any desire to interact with the defendant at all.
Yeah. Mr. Thompson, thank you very much. Is there anything you want to add?
Well, I appreciate you taking the time and waiting for me while I tried to figure out copy and paste the link for the Zoom meeting. That's not my strong suit, but I do appreciate your time, and I appreciate the opportunity for you to be able to tell people, hey, this is the real scoop. This is what's really going on here, and maybe debunk some of the rumors and gossip and stuff that distract folks. So thank
Well,
you for your help.